Hello and welcome to Employers' Legal Risks from its Remote Workforce and How to Address Them. This is part one, the legal perspective. This is hosted by Brandywine Technology with presentations by Katherine Witherspoon Fry with Offit Kurman and with Jason Clarke with Williams Insurance, who you will see in our next presentation. Brandywine Technology, we have been in business for over 20 years and we specialize in IT staffing. We provide you short-term, long-term, and permanent placements for technical talent. And we bring that technical perspective of knowledge of skills to provide you with better IT people. Our first presenter, Katherine Witherspoon Fry. Katherine is a principal attorney in Offit Kurman's Wilmington, Delaware office. For over 25 years, she has provided her clients with robust representation in matters of employment and related business law. Katherine represents the council's employers and executives in all facets of employment relationship, including hiring, termination, discrimination, non-competition, Fair Labor Standard Act matters, issues regarding family and medical leave and other leaves, whistleblowers' complaints, and regulatory matters. As a litigator, she is well aware of the nuances of law necessary to draft effective restrictive covenants, severance agreements, and employment contracts. Along with her over 250 colleagues, she represents companies and nonprofit organizations of all sizes. She has defended companies under investigation by both U.S. and state departments of labor and handled multiple matters before the EEOC. She also mediates cases and teaches at the University of Delaware's Business School. Katherine, I'm going to turn it over to you.
Well, thank you, Kristen. I appreciate that. I appreciate the invitation to talk today about workers' comp and people who work at home. It's a liability for employers that a lot of people just don't recognize. And Kristen approached me about doing it, and I said, that's a great idea because I don't think a lot of people are thinking about this. So right now, during COVID, a lot of people are working at home, and this has been a recent development. We have seen a huge number of our clients having people work at home, and some of them have been almost exclusively. They'll have one person in the office to sort of keep it going and send faxes if anything, get mail, that kind of thing, and otherwise they're remote completely. So some things that don't occur to people when normal circumstances are in place are now occurring to people about liabilities they have from their workforce being at home. So in general, an employee injury or illness is compensable under workers' comp if it arises out of and in the course of employment. And that doesn't matter where it occurs. It can be at home. It can be walking to their car in the parking lot. It can be walking into a client's place of business. Arising of the term of art refers to what the employee was doing at the time of the injury. Were they working? Were they working right then? If they were not working, then that's not arising out of. If they happen to be hanging out someplace having lunch, does not arise out of if they slip and fall on the restaurant floor. In the course of is another term of art used by courts, and that refers to when the injury happened. Was it on the clock? So they're very intertwined definitions there, arising out of and in the course of working. So employers, unfortunately, are faced with the court's decisions that their lack of control over the conditions of the employee's home office is irrelevant. It really doesn't matter if the employer has any control over whether there are dogs running around and someone trips over them. This is a surprise. This is what is a surprise to many companies because they're not used to having to deal with so many people in so many homes with so many hazards. So the hazards of an employee at home constitute the hazards of his or her employment or workplace. Can we have the next slide, please? So basically, there are a lot of cases on this, but I found a good case example, which I think a lot of people will relate to. It is an Illinois case, but it's very similar in a lot of cases. I'm sorry, in a lot of states, in a lot of cases. You can collect workers' comp for injuries suffered at home while performing work. In this case, the duties of the employee included selling telephone equipment services to business customers. So the claimant was working when he carried his demo equipment and his computer and his printer on his shoulder when he walked down the stairs from his apartment to his car. Query whether it was a good idea to carry lots of heavy equipment on his shoulder, but that's what he did. And of course, the employer had no control over him doing that. However, we'll see that this was not a problem for the court or for the people who decided the workers' comp matter, the board. So he suffered a back injury when he was carrying all these really heavy things on his shoulder. He was unable to return to work. Interestingly, while he was getting better, while he was convalescing, he got a master's in business administration from Northwestern University, which I happen to know is a very good school, so he had to work very hard. He also admitted that he didn't perform a job search during the time he was out healing. And we've all heard stories like this. But whatever, the arbitrator found that the injuries that he sustained were permanent. He was totally disabled. Didn't matter if he was able to get an MBA degree, didn't matter if he looked for anything else. He got permanent total disability benefits for life. The employer appealed to court, but the court affirmed the award. And so this is an instance, an example of a court saying, I don't care if you could control the fact that he held this stuff on his shoulder. I don't care if you could control the fact that he had to walk down flight of stairs. You're liable. Workers' comp has to kick in here. So next slide, please. So the burden of proof, that's a legal term that refers to who has to prove their case, who has the burden of proving that this is actually what happened, that someone is entitled to a claim. In workers' comp, the employees have the burden of proof that the injury is work-related. Again, if he's coming down the stairs going to lunch, that's not work-related. It's his burden to show that he was engaged in work when he was hurt. The employee has to show that they were working in the interest of the employer at the time the injury occurred. So that's going to be a really fact-specific analysis in each case. So I'm not able to say, hey, every time someone's walking down the stairs and injures themselves holding equipment, that it's going to be workers' comp liability. But I'm also not able to say that just because of these specific circumstances, that's why this person was liable and someone else may not be liable. It's a very, very fact-specific analysis by the court and the board. The first step in these, as most people probably know, you have to go to a board, an administrative body that will hold or not hold in the person's favor. And then either party can appeal to court. Court's the end of the road. That's about it. I have seen people take it up on appeal to a higher court, and that can happen. Usually not. Usually it's just a trial court and it's over. But the point of this background is that to emphasize employers are responsible for providing the same safe work environment for people at home as for people who are working in the office or on company property on a work site. Next slide, please. Can we have the next slide, please?
Bear with me.
So what do we do about this situation? What do we do to limit the employer's liability? We want to do some of the following. We want to create a really good teleworking policy that sets expectations. Make sure that people are actually clocking on and off, clocking in and out rather, and that means that they are setting the times when they're actually working, so that something that happens to them on a break, something that happens to them when they're eating lunch is not on the employer. That's one of the things you want to put in your teleworking policy. I'm doing these all the time. It's pretty short and sweet. There really isn't that much to it. There are just a few nuances that you really need to make sure you include. You can let me know if you want to discuss any of that. You need to establish guidelines for the home office, such as a designated work area, certain equipment, what are they going to have, what are they going to provide themselves, that kind of thing. You should provide training related to the workstation setup and safety measures, including ergonomics, because people can make claims for workers' comp for things like carpal tunnel syndrome and bad backs because they've been sitting in a bad chair. You don't want those things happening to you, so training is always a good idea. And then when possible, I know this is not always very practical at all, and especially during COVID, but it's still a suggestion. When possible, conduct checks of the employee home offices if you can to help identify and eliminate work area safety hazards. So those can be things like exposed wires, tripping hazards, fire hazards, electrocution hazards, water hazards, believe it or not, and things like, hey, do you keep the dog out of the room while you're working, kind of thing. And maybe that seems like overreaching, and maybe that's not what you want to do with your employees. Understood that, you know, conducting in-home inspections might be a little much, but it is still, you know, a recommended practice if you have doubts about a particular employee, for instance. You know, why not? And just reserve the right to do that in your policy. Always a good idea. Next slide, please. So this is really key. You want to distribute a safety checklist to all your teleworking employees and keep up with who's at home, who isn't, track it carefully so that you know who's getting the checklist. It has things like check for electrical hazards, check for fire hazards, tripping hazards, like I said before. I do call my dog a tripping hazard because she's really low to the ground, and that's kind of not what's included in tripping hazards. But what you want to do for both the policy, the teleworking policy, and the checklist, you want to have people acknowledge that they received it, that the employee has completed the check, that they understand the policy, and that they can be disciplined if they violate the policy. If they haven't done the safety checklist, for instance, they haven't used it, then they can be disciplined. So that if something happens and it's, oh, well, you know, a fire started from my, you know, my lamp at work, then, well, did you check for electrical hazards? Oh, well, maybe not. Well, then, you know what? You're subject to discipline for that. And that's something that you then have in your back pocket to protect you as an employer. Next slide, please. Set the fixed work hours that I mentioned. Make sure you've got meal and rest periods. First of all, you have to watch that for workers' comp purposes because, as I said, they are injured outside of work hours, they're in a break and so forth, then it's not compensable under workers' comp. But you also want to make sure that you're following the FLSA requirements and paying them for every hour worked, that they're not working a ton of overtime, that they're not underworking, that they are getting overtime if it's worked, they are getting appropriate meal and rest periods. So make sure you really emphasize that at home to avoid those wage and hour claims. I've had some nightmarish wage and hour claims. There's a penalty. There's, depending on the state, there's double damages, treble damages. The penalty, the fine is paid to the United States Department of Labor. They will litigate at a drop of a hat. You really want to make sure you do this. Make sure you emphasize accurate timekeeping at home and in the office. It's a little easier to enforce in the office. So forbid overtime without the express permission of the supervisor, because that's where you're going to run into trouble. Oh, well, you said I had to finish this. Well, but you didn't ask specifically if you could work overtime. I would have told you you could have worked it the next day, but nobody checked, nobody approved. Therefore, if the hours are worked, they have to be paid. People don't seem to understand this sometimes. If you work it, you pay it. That's the rule. It doesn't matter if you would have said, no, do it the next day, don't stay late. So something to think about there too. Next slide, please. Now, be careful, very careful about retaliation. So retaliating against someone for filing a workers' comp claim is, you know, independently illegal of other actions you might take. Even if the workers' comp claim is a bad claim, you know, it's not compensable, it's absolutely a joke, But if you let someone go or change out their job conditions, you are actually retaliating. So, to name some things that are considered retaliation, you cannot change their shifts, you can't change their work location, you can't pass them over for promotions, change their abilities to earn extra like tips or commissions. Of course, you can't fire, demote them, cut their pay, or harass them because they did any of these things. So even if it's absolutely ludicrous, bide your time, and when it's dismissed, then think about documenting other misbehaviors or using other misbehaviors that had occurred before, disciplinary record, etc., if you want to get rid of that person. That's basically the right approach is wait and see. So often, crazily enough, workers' comp retaliation is worse for the company than allowing the worker to recover at the reduced capacity and provide the time off, because the penalties for retaliation are much worse than what they would be if you allow workers' comp to pay for it. So just a word to the wise. Next slide, please. So this is my contact information. If you want to get a complete checklist from me, I'm happy to share that with you. And further tips on policies, practices, I'm on LinkedIn. Feel free to reach out. Thank you.
Katherine, thank you so much. This was great information. And as always, we welcome your feedback on our webinar. And thank you so much for joining.